Hello there, welcome to Boomer Time. I'm Nancy Cogar, and I am glad you're here as always. We are going to talk about probate. You probably have heard of probate. You may not know what it is. It's confusing. What needs to be probated and what doesn't? When do these scenarios come up? Here's a scenario that I wanted to share with you because I see this coming up quite often, actually. Let's say mom didn't have a will. All right, and she dies. One of the siblings, say there's 4 siblings, one of them has lived in the house and doesn't want to leave. But after mom dies, the case ends up in court and suddenly he's being asked to pay rent or move out of the property. Does that seem fair? Well, it happens quite often because the house is an asset of the estate. It's not the brothers per se. And that's all if there's not a will. Sometimes if there is a will, we can have a more specific distribution. But those instructions, as I've said with everything else, always have to be specific. So that's just one example. And I thought it would be important to kind of talk about what can go wrong, because there are a lot of things that can go wrong with probates, and the process itself, because there seems to be a lot of confusion about that. So that's what we've got in store today. You know, there is an issue sometimes when people pass away and people start talking about, have you done a probate? Are you going to do a probate? What in the world does that mean anyway, right? What's a probate and when am I supposed to do it? And where do I go? What am I supposed to do? Those are not unusual or stupid questions. Makes sense if you're not familiar with it. So let's look at that. Let's look at what requires a probate. What kind of property or assets have to go through probate? And when? What makes a difference? How can you avoid probate? One of the biggest ways is to have estate planning in place that helps you avoid probate, like a trust. That is a major way to avoid it. But if you've got a will, chances are it has to be probated in some form or another, limited form or all-out probate. So where do you go for a probate? You go to the probate court, right? Here it's a chancery court, and you have to file a petition. And you have to have the will attached. If there is a will, you need the original will. That's another problem. If you don't have the original will, we'll talk about that in just a minute. We're talking probate today. What is a probate? When do you need it? What do you have to do? And what goes through probate, right? So we're going to talk about some of those things today, and I do hope that it helps to clarify not only the process, but help you to prepare, right? Because there are some ways you can avoid probate altogether or have a more limited probate, and that can save time. It can save expense. It can save costs, attorney costs, court costs, time, as I said, costs something. And it can help with directing really how you want your assets to go. So there are going to be some resources online. You know how I like resources at nancycogar.com that you might check out. If you've had a loved one pass away recently, I think that'd be a good starting point because there's some general guidelines there. What you're going to need when you prepare, what you're going to need to do when you are ready to establish probate. Hey, here's something you may not have thought about. Do you even qualify as the executor? That's a fiduciary position. That sounds very legal, doesn't it? It is, and it requires some things. So if you are not qualified, could be something as simple as having a prior conviction for some felony crime. If If you've got that, you are going to be disqualified from serving. So look for those resources. And of course, got the Boomer Time Blueprint out, and it is available on Amazon. So I hope you'll check that out and buy yourself a copy. Tons of resources, tons of helps in there. And I'm looking forward to hearing from people too about how it's helped them. What you like best? Let me know. You got a question that wasn't in there? So let's talk about, okay, you use a scenario. Let's say grandma dies. And grandma left a will, right? It's from 1986, so it's an old will, but you've got the original. You can still file that with the court. And that's exactly what you need to do. Well, really, in my court, you need to hire a probate attorney like me. Okay, so we will draft a petition to open the estate. That's the first thing that needs to be done. You need to give us the original will. You need to give us a death certificate. Of course, we need to prove that the person has passed away. You'd be surprised at what some people try to do when it comes to money and assets, right? And you've got to make an appointment with the court. So here, that's the clerk and master's office in the Chancery Court, and you will go down there as the petitioner seeking to be appointed as the executor. That's if there is a will. If not, you will seek to be the administrator, and that will create a whole other kind of scenario. But like I said, you need to be qualified. Once you get that probate established, and you may hear this from people, banks especially, when the letters are issued to you, you will have the ability to do things on behalf of the estate. You will not if you don't have those letters. And as I said, banks are quick to say, where are your letters? And they'll freeze the accounts. And, that's just what they have to do. So there's a process. There is a process that you have to follow. And I'm trying to help explain that to you. So once we get the petition approved, then there is an estate created, right? And what's the first thing that happens after that? Kick brother out of the house? No. Notice to creditors. Notice to all the beneficiaries. We need to give notice to the world that this person, your loved one, has passed away and an estate has been created. We do that for a couple of reasons, right? If you're mentioned in the will, then you deserve notice, due process, that you can expect something from this estate. And creditors, of course, need it because they may be owed some money and would want to file a claim in the estate. So that's really the first thing. Then you can start collecting once you have authority. You can start collecting assets of the estate. Call it marshaling assets, but it's something that you have to do to make sure those assets are protected. No one is taking some or all of that. It doesn't belong to them. It belongs to the estate, right? Make sure you set up an estate account and you marshal or collect all those assets in one place. Yes, and that does come back to the house, right? Sooner or later, if there's no disposition for the house, and say their claims, right, you got to pay stuff, the house might need to get sold. But you can't just do that on your own. You've got to ask the court for permission. So this is a slow process, but it's the process we have. So you would pay those debts and expenses and even taxes. And there's different types of debt. Wanted to talk about that. So, credit cards, things like that, medical debt, credit cards, those are all considered unsecured debt. It means they don't have any collateral attached to them, no property, right? So they're just general unsecured creditors. Then if you got a mortgage, say there's a mortgage on mom's home, and after she dies, and brother and you all stop paying the mortgage. After all, it's not your mortgage, right? It's not your house. Well, no. So what's going to happen there? Can you guess? Yeah. Yeah. The bank is going to give notice of a default, and there's a danger of foreclosure. So that's an example of a secured debt, right? It's the collateral is the house. So if you stop paying, they're coming to get their collateral, right? So you're going to have to, as the administrator, you're going to have to be aware of all these debts, and you'll have to be aware of what gets paid when. You can object to certain claims if there's not enough evidence supporting it, but this requires having someone who knows what they're doing. And all of this is before any distribution to beneficiaries. That's going to come down the road. You got to wait because you got to pay all the debts. And sometimes those debts are secured debts and priority on top of that. So what is a priority debt? Well, that's like taxes, the IRS, right? And Medicaid, when they come and recover for nursing home benefits that are paid out. That's going to be a priority claim. And that means even if, so let's use the example of brother again. Let's say brother, the will gives brother the house. Let's say that, right? And you decide, well, he can stay in the house because after all, he's going to get the house. And everybody's cool with that. Well, if there's a TennCare claim, or like we would have here in Tennessee, or a Medicaid claim, say they file a $200,000 claim in the estate. That's not unheard of. Those claims can be very, very significant. Well, because they have that priority, they can interrupt brother getting the house, unfortunately. But yeah, that's a surprise for a lot of people. Unless you can come up with another way to pay the debt down or show that brother has an extenuating circumstance or something, those are very limited options. You are going to have to sell the house in order to pay the debts of the estate. See? So this is something that happens before anybody gets any money. And what if there isn't any money, right? That happens. That means that the estate is insolvent and maybe it has limited resources. Guess who gets that money first? Priority claims, administrative costs. You can see where I'm going with this. Beneficiaries don't automatically get something from the estate. And that's something that I've noticed recently. I've had more cases where beneficiaries or the administrator that's appointed, they want to do things their way, right? They think one of the beneficiaries deserves to have the house. Let's use the example of brother again. He always took care of mom, and so he deserves the house. Sure, the house is worth $300,000, but let's give it to him. No, that's not going to work, people. It's not going to work because you're giving away something for nothing, right? It's the estate's property. It's not your property, and you have to get permission from the court to do something like that, which is very difficult. And if you can reach a settlement, something like that, you don't have claims at issue, then you might be able to work it out. I try, but there's some really narrow circumstances there. So that's something you definitely want to think through very carefully. So I know it leads to frustrations. I know it leads to surprise sometimes. And even though it may seem like the right thing to do, sometimes it's something you can't do. So what needs to be probated anyway, right? Well, if you've got, I like to limit the probate pot, really is how I say it. I'm a visual person. So when we meet with a family, look at what needs to be probated and what doesn't, right? What needs to go into that probate pot? So I would say anything that was individually held by the decedent, the deceased person, let's say a bank account. There's a bank account with $50,000 in it. And it didn't have a beneficiary, didn't have a joint owner, none of that. Well, that is going to most likely have to go to probate. And you will have to ask for that to be liquidated and paid into an estate account. Doesn't get automatically distributed. You see where I'm going with that. What about a life insurance policy? Well, if it's got a beneficiary, then that goes outside of the probate pot. So that's a good way to get something direct to a beneficiary if you want. It would get paid directly to the person who is the beneficiary. They just make a claim. They'll have to show that the person is deceased, of course. But then that money would get paid out directly to them. What about mom's house? Tennessee law here says that the heirs at law or the natural heirs can administer the real estate if they desire to do that, and if it's not mentioned in the will. You know, sometimes things that are permissible are just not practical. And that's what I find with that more often than not, because there is so much fraud. So you're dealing with title companies, real estate, you got a secured debt, right? Remember I mentioned the mortgage. You're going to need to tread lightly there. You are going to need to either do that very carefully. I often suggest people consider a more limited probate to help with the real estate, or ask the court for permission to sell the real estate. That is the safest way to go. And the title companies, for obvious reasons, like that, because they've got an order of the court saying they can sell it for this amount to this person, and here's what happens with all the money. And it would pay off that secured debt that I mentioned before, because the house is the collateral, right? So they've got their fingers in it. The bank's got their fingers in it. So they're going to have to be paid what they're owed, whether it's $50,000 or $300,000. If the house is worth $310,000, well, you're not going to have that much left over, right? But that's how that works. And I get asked a lot about vehicles. Actually, vehicles, most of the time, do not need to be probated. But there does need to be something done to help with getting the title in the next person's name. And you need to show that the decedent wanted it in that person's name, or you just have to sell it to benefit the estate. But it's not as easy as you think. Other personal property, most of the time, if it's just a couch, dishes, housewares, those type of things, you don't have to do much with those. But make sure, if there is more than one heir, that those have to be distributed fairly and equally. One person can't go in there and cherry pick what they want, right? And then leave all the crap for the brother or the sister. I've seen that happen, but you can't do that. If you do it, you're going to have to expect that somebody's going to want you to give that stuff back, because it's not yours. It's the estate's, right? So, word of warning there. Okay, so what's not a probate asset? And that means it doesn't require the court's administration. Well, something that's jointly held, right? If it's you and your spouse, and if one of you passes away, it'll vest in the other. That's according to my law. Payable on death or transfer on death accounts. That's just like a beneficiary designation. So same thing, like I used as the example for insurance. And then something that's titled differently. I'm not going to talk about this today, but if you had a trust and say you titled property in the name of the trust, well, that would eliminate the need to have to go through probate, and the property would pass according to what the trust says. So It's a slow process, slow. And, looking at my notes here, I remember that I wanted to talk to you about the difference between if you have a will versus not having a will. I think that's important to touch on because you can create an estate either way. It's called an intestate estate if you don't have a will, and testate if you do have a will. So what's the difference? Well, intestate, that means the deceased person did not leave any directions or instructions for their property, right? So you have to rely on state law, and that is set out in the law exactly who gets what and who doesn't get what. So you're really eliminating the opportunity for you to do what you want to do with your stuff, quite frankly. So if you have a will, and if it's valid, right, enforceable, it's a whole nother story. And it's the original, okay, you get through those 3 categories there, then yeah, you can tender that to the court. And it will be a testate estate, which means it will be administered according to the decedent's guidelines in that will. That's a much better way to go. I had somebody recently very specific about what they wanted to happen to their property. They never talked to me about it. They never wrote it down. This was the surviving spouse that was telling me, well, they wanted this, they wanted that, they wanted this, and wanted that. That's all great. But really, legally, I can't do anything with that. It's not worth a hill of beans, as they said. Oral doesn't work. Plus, that person's dead, so I can't even confirm that that's really what they said from a practical standpoint, right? That's called hearsay. You hear a lot about that. But really, the point I want to make is if you don't have a will, you're setting yourself up for just whatever the state says. That's how things are going to pass. And it is going to have to pass through a court, chancery court, most likely. And what comes first, right? Notice to creditors. I think that's the biggest confusion that I see is people don't understand that, the will may say one thing, but there's a process to get to those distributions. And the process is, of course, what we've already talked about, establishing the probate, tendering the will, providing notice. Well, okay, what happens after that? Well, that's when you see notice in the newspaper, right? Everyone learns that this person has passed away. And that may be something you want to avoid too. Who wants their estate publicly announced to the world, right? Well, if you don't choose another alternative, that's exactly what's going to happen. It's public record, people. So if it's out there, creditors are going to see so-and-so died, and that's their opportunity to file a claim. So maybe credit card, maybe Discover card, right, files a claim for $500. It may be a utility bill that was past due, right? It could be a personal debt that somebody says they were owed. All of those have to be filed very specifically according to instructions that are required under the law. And you do have an opportunity as the administrator, the executor, to object to those claims. But again, that's a very narrow circumstance there where you have to follow you see something happening here, right? Follow the rules of how you go about doing that. And timing's important too. You wait, you lose. So if you don't file it timely within the deadline period, guess what? You're going to end up paying it, or the estate's going to end up paying it. So that can be a big problem. especially if the estate doesn't have a lot of money. You're going to get into a situation, like I said before, where, even if something's given to somebody, you're going to have to find another way to pay some of those claims, especially if there's a security interest attached to it. I know this is very complicated, and I say that because, well, it's further proof of what I say all the time, right? You have to plan. You should plan. You should not leave it open to all this exposure. Why would you do that? Why would you spend your entire life working, accumulating things, loving people, wanting to leave something better for people, maybe a charity, even your church? You have the right to do all of that, but if you do nothing, the state has to step in and do something, make some sense out of something that doesn't have any sense and did not have any order provided to it. You want to learn more about those kind of things, you can buy my book. It's available on Amazon. I've got a lot of stories, more bad circumstance stories, and good when you do the right thing, right? Like, you got to expect that you're going to get good results. But I would say most often that people are in a big rush. I know that doesn't surprise you, right? And the court is not in a rush, okay? Because they don't have to be, and also the law has different deadlines and timelines and things like that, and they can't push it forward. They have to wait those deadlines and timelines out. So don't be in a hurry. If you've filed a probate, listen to your lawyer. Don't give people things until you are ready to do that. And I always say to my clients, let's get an order from the court. I want the court to authorize everything you do. Wouldn't you want that, right? You don't want someone coming back to you and saying you couldn't do this or you couldn't do that or you took this or you took that. Hey, I see that too. There are cases where people file things in court and they magically forget that they have brothers and sisters. So, that kind of stuff happens. And that's what helps to have a professional on your side too. So I'll be back in just a minute with some concluding thoughts, but stick with me, and I got something else I want to share with you, so don't go away. Welcome back. I'm just wrapping up here, but I did want to share a couple things that I often see as surprises, right? Unrealistic expectations. That shouldn't be any surprise based on what we've talked about today. You got to do what the guidelines provide. You cannot work outside of that, and that means you have a certain timeline, deadlines, and restraint and obligations. Debts have to be satisfied first, if they're valid. But there's a process to challenge whether they're valid, so that requires action. Paperwork, deadlines, fiduciary liability. This all requires action on your part. So it's very proactive and deadline-oriented. Delays cost money, right? You're going to pay court costs, you're going to pay attorney fees, you're going to pay claims potentially, taxes, right? These are things that have to come out of the estate. And one other thing to all of you that are planning or getting ready to plan, really think about who you pick to serve as executor, because it's not an easy job. It's not really a fun job. It's very demanding. So you want somebody who doesn't get their feathers ruffled easily, who understands kind of the processes that I've talked about. Somebody that works well with others. Right? You don't want a big bullhorn coming in and telling you they're going to do it this way and that way, and they don't care what you think. That is not going to work. So I hope this has been helpful. And like I said, go to my website, nancycogar.com, and there will be resources specific to this episode, and also all kinds of other resources you can find. There's ability to search that. And don't forget to go to amazon.com and buy my book, Boomer Time Blueprint. I'll see you next time.